To give us their perspectives on that subject matter, we've got two gentlemen, as you may have seen right there. Ahmed Raji is a senior advocate of Nigeria. He joins us from Port Harcourt virtually. And we also do have Abdul Fatai Sambo, who is an associate professor, Department of Public Law, Faculty of Law, University of Ilorin. Gentlemen, good morning. Thank you for joining us on the program today.
Good morning.
Mr. Raji,
good morning. Thank you for having me.
Yeah, let me start with you, Mr. Raji. Of course, you must have also heard and probably read as to the backstory concerning how this happened, why it may have happened, all those reasons notwithstanding. So for you, I mean, even though some of those thought there might have been a lot more to this, how does this come across to you? Is there more to this that meets the eye for you?
Well, it might take time to to know what really happened, but based on what Mr. President read to the Nigerian public, that the former CJN resigned on net ground. I do not think we should doubt Mr. President. And coupled with the fact that in the same speech, he conferred on him the highest honor that can be given to anybody who has held such kind of an office, that is the GCON. Well, maybe bookmakers or history makers can research further in future and see, but as of today, we just have to believe what Mr. President has said. That is the way I would look at it.
But
that the former CJN resigned on health ground. Okay,
so correct this if it's wrong. It sounds as though you say, well, let's just believe it, but to you, there should be a lot more questions than what is out there at the moment.
I don't want to go that route. I think the best thing is to move forward, especially when the acting CJN has said they are all one, they are all united, and they better look into the future and see how best judiciary can be enhanced, the performances, and then, because there are a lot of challenges. And the best thing is to, I think, sit down, look at the challenges, and fashion out the best solutions to most of the challenges. These challenges, some are not about any particular human being, but rather because of the system. I would rather go that route rather than trying to apportion blame here and there. That is my own take.
Just before we go into those issues you're trying to raise, Mr. Raji, is this something you saw coming?
Well, in life, anything can happen as human beings. If death can happen to anybody at any time, what is resignation? We must be prepared for any event. Not specifically, but it is not surprising that somebody has resigned on ground of health. It's not, to me, a surprise.
Professor Sambo. Okay. Prof. Sambo, it appears as though some part of what Mr. Raji is saying comes across as though he's saying, let sleeping dogs lie, so that you can look into the future. But from what you've seen now, is it all straightforward?
Well, thank you very much for having me. But then I would like to say that anybody can resign at any time. But if you look at the provision of the Constitution as regards the resignation or the removal or the appointment of Chief Justice of Nigeria, you see that the Constitution does not really envisage a situation where somebody would leave his job on health ground. The simple reason is that if you look at Section 231, particularly subsection 4 of the Constitution, when you read together with subsection 5 of the Constitution, you would discover that this is one of the areas in which the CJN can decide to resign, and can decide to leave office. But then the issue is, if the CJN resigns purely on health ground, you look, if you look clearly, a camp reading of section 231, subsection 4, will show that there are two circumstances under which a person may actually vacate his office. Almost three circumstances. For instance, now, a person, the office may be vacant. The office of the CJN may be vacant on head grant. On resignation. It may be vacant on the fact that death. It may be vacant by virtue of removal under section 192 of the 292 of the Constitution. But the thing is, subsection 4 of section 231 is saying that yes, if the office of the CJN is vacant, or if the person holding that particular office is unable to perform the function of the office. These are two different situations.
Okay. Prof, just give us a moment. We're going to go back to you for a lot longer. But, Mr. Raji, when you say that we need to look forward, what will that mean?
What I mean, for example, the court is over congested. What are we doing about that? Today, in the Court of Appeal, Lagos Division alone, they have over 10,000 cases in their docket. And in a year, they can only run about 600 or 500 cases. So, and every year, we have 1,000 cases being filed, over 1,000 cases for appeals. How do they cope with it? Which means in another 5 years, we'll have a backlog of over 20,000 cases. This is what we have to do, forensic analysis, and find out, develop schemes by which we can decongest the courts. Otherwise, in the nearest future, the court system may fail. This is what I believe we should focus our attention on. It's beyond individual justices. This is what I'm looking at. Not just, his lordship has put in, it's his right to resign, and he has resigned. I think we should let the sleeping dog lie and wish him well. But to start, yes?
What do people do? Are we supposed to just forget about all those cases or issues that were raised in the letter that the justices raised questioning administration or maladministration in the judiciary at this level?
Well, that should not be the main focus now. This is the point I'm making. All those may be looked into maybe later, but that should not be the primary focus. Otherwise, the current people who are there, they will lose focus. They should concentrate. The court is over congested. When you file an appeal in the Supreme Court with the best of whatever, you may not get it heard until after 7 years.
But Mr.
So
Raji,
these are the issues.
well,
yes.
Perhaps those issues raised in that letter, leaked as it may have been alleged, could actually be an agenda for the new CJN. Otherwise, these issues that you have raised about congested courts and all of that, they are things that have been discussed over and over again, even until this moment, and nothing has been done. So by way of setting agenda for the new CJN, what are some of those issues that you think need to be addressed as quickly as possible in order to lay a foundation for the issues you think are primary?
Congestion of the courts.
Yes.
This is very, 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 very important, congestion. And then a situation where any kind of appeal can end up in that highest court should be looked into. That should be looked into. Because all over the world, let me say, in most advanced democracies, not all appeal terminates in the highest court of the land. In England, the Supreme Court, formerly House of Lords, will not take more than 20 appeals in a year. In an election year here, the Supreme Court at times will attend to about 600 cases in a year. How? Then you have a land matter traveling from Shinkafi village up onto Guzau, going to Kaduna and traveling to Abuja. Why? Or from Okrika, traveling to Port Harcourt, from Port Harcourt then to Abuja. Why? Why should such matters end up in the Supreme Court of Nigeria? I know this is beyond their lordships. It is the fault of the Constitution. This must be looked into. This, I believe, is the immediate and urgent agenda that should be pursued by their lordships, by way of proposal to the National Assembly to limit the jurisdiction of the court, and any appeal to go to them must be by leave, and not a situation where every Tom, Dick, and Harry will just be throwing an appeal and then the whole place is congested, over-congested, and they are overworked. And then, apart from this, their remuneration is totally out of it. It is very, very bad. One of the senior lawyers, Mr. On, just filed a suit now, pressing for a review of their salaries and emoluments. A situation where the entire Supreme Court justices, what they earn is not what up to an MD of a bank earns. That is the private sector. Or a situation where a director in the federal government parastatal earns more than all the 10 justices combined. What kind of a system is that? What kind of a system is that? And they are now complaining of this. These are all the major structural problems that should be looked into. They are not being well paid at all. At all. I repeat, they are not being well paid.
All right, Mr. Raji, we understand you have to run, but Makwe just got one question for you before you go. Makwe?
Well, been tied nicely with that one. Thank you so much for joining us, Mr. Raji. Let me quickly read something to you. And I know that, as Chimlin did say, you're trying to let sleeping dogs lie. However, some people will say that if you do not try to correct what has been noticed before, institutionally, that the problems could very well rear their heads again. The words of the 14 Supreme Court justices in that leaked letter is very hard to ignore. And I'm going to read it again just to press it home. It says, Your Lordship, with all due respect, this is the peak of the degeneration of the court. It is the height of decadence and clear evidence of the absence of probity and moral rectitude. This act alone portends imminent danger to the survival of this court and the judiciary as an institution, which is gradually drifting to extinction. When Supreme Court justices use words, they don't use it lightly. They use, they write what they mean, and those words, each one of them carry a lot of weight. When they say that the court, the judiciary as an arm, is going into extinction, doesn't it say a lot about the amount of work that needs to be done by the new CJN who is now on the seat? Where would you suggest he starts from, especially in the area of confidence?
Well, that is very good. That what they have written should be a lesson to all the justices. Should be something when you wake up every morning, you look at it. Oh, these are our complaints, let me avoid it. Oh, these are our complaints, let me not move near them. I think beyond that, I do not see what they are going to gain by saying, oh, we are going to probe Mr. A or we are going to probe Mr. B. That is the point I'm making. They should use it as something to learn from. So maybe not a probe.
Maybe not a probe, sir. Maybe, what about institutional check? Because people have talked about how this, it's unheard of for Supreme Court justices to write. Some people have likened this to a mutiny. And it was seen that there was no other way out for them to have checked what they felt was happening within the system. Do you think that there is, beyond a probe, in terms of looking at the future, is there anything you think can be done within the judiciary itself to avoid this sort of letter being written again?
I think, well, maybe it's from structural checks and balances in the system. Some structural checks and balances, but looking forward, not looking backwards. From structural checks and balances in the system. Perhaps in the amendment to the Constitution, a whole lot of responsibilities on the CJN may be reduced.
Mr. Amaraji, we do appreciate your time this morning. We would have loved to go a little further because it appears as though there are some interesting areas that you're going right there, but unfortunately we have to let you go and catch your flight.
No, you can continue, no problem.
Okay.
I can go beyond it.
All right, in that case then, just what Mark White did ask you, follow up on that one. So if you say looking forward without looking backwards, how do you look forward without knowing where you're coming from? Because it's from where you're coming from you want to correct so that you get to where you intended to go.
Yeah, that is, you use it as a template. You look at it. What were the errors you were talking about? And then how do we guide against it? That is my point. How do we guide against the errors? Some of them may be individual errors or collective errors or systemic errors or structural errors or whatever it is. But look at it, what the complaints are, learn from them, and then move forward. That is all I'm saying. I'm not saying they should ignore whatever the observations. I'm not saying that. I'm not saying the observations should be ignored. All I'm saying is that they should just learn from the observations or the perceived errors or wrongs or what have you, and move forward. Because
my apologies for butting in. My apologies for butting in. Talking about moving forward, it's a long time coming. Something that you said earlier, also kind of referenced in that letter that Malkwe quoted from, is that there is a risk of the judiciary going into extinction. You said it earlier in one of your responses to us here this morning. So one is wondering, how did we get here in the first place? Because back in time, well, Chamberlain did talk about us looking back as a way of looking forward. Back in time, the judiciary always had respect. Even during military era, they always had that regard. They always had such institutional, strength and framework that kept it on. At what point would you say we lost it? Talking about it as an institution without looking at the individuals involved. At what point would you say we lost that importance, that pedigree that the judiciary had, whether it was military rule or civil rule?
Well, it's not about the point. It's about what are the factors responsible. For example, I've identified congestion in the courts. I've identified poor funding. And perhaps one of the observations should also be the manner of appointment. So it is not about the point. But, well, if you want me to locate it, perhaps it was when the military came in. Because in the First Republic, we had a judiciary that was functioning very well. Based on what I read, I was not a participant. And then it was growing very well. And suddenly we had like in the Western states, we had Western Court of Appeal, Western State Court of Appeal, and things were, moving very well. But when the military came, all this over-centralization and what have you has brought about a lot of problems. So we may locate it. That may be one of the points. For example, I've identified why, or I've argued that cases, not all cases should travel up to Supreme Court. Each region or each geopolitical zone should be the final arbiter in respect of some matters. If you carry a land matter from Ofiki in Oyo State, it goes from customary court to the magistrate court to the high court in Oyo or Shaki, then to the Court of Appeal. What is that case coming to do in Abuja? What is it coming to do? Or you have a chieftaincy matter from Ikere Ekiti and traveling from Ikere up until Ado, there's a Court of Appeal now in Ado, then traveling to Abuja. What's he coming to do there? Or one from Onitsha, traveling from Onitsha up until Oka, then Oka. What's he coming to do there in Abuja? What I'm trying to say is, perhaps the structure should be looked into, whereby the regions can now have some kind of Supreme Court or final court, so to speak, on some matters, and that those that will come to this Federal Supreme Court will be areas of common concern. like foreign relations, currency, and what have you. And not just all these kind of matters, I mean, chieftaincy, land, marriage, and all those kind of things. That is maybe. Then funding. Funding is very, very crucial. A Supreme Court judge in England, or justice in England, is remuneration or allowances far, 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 far above what judicial officers earn in Nigeria. Well, we are not the same as UK, but we should not fall that too low. A situation where what is Supreme Court justice earn in a month is not up to $1,000 per day. Cause for concern. Then, if you read their letter, they were complaining about lack of internet access. Then diesel to in their homes, then generators. Some of them, they've not been accommodated. They still, no official quarters. What? So then there's a problem of funding. So that should be looked into. So these are some of the issues. But what I'm not saying you should ignore what they have written, but you should use it as a template to move forward. That is my take.
Well, the associate professor of public law, for instance, and the public is quite interested in some of these things as they're playing themselves out. So for you, given all the scenario about the resignation of the CJN, new person being sworn in, and then he's being given GCON, so would you also think, or do you share the same perspective as Mr. Raji saying, look, yes, much as we need to use that as a template to move forward, what do we then do? What would you have us put in place to ensure this kind of scenarios doesn't play itself out again?
Thank you very much. I think we have to really, I share the perspective of the learners to a certain extent. But I also believe that if you look at, I wouldn't believe the resignation was clearly based on health ground. Yes, the president has said based on health ground. And the CJN, the former CJN also said yes, it was based on health ground. But clearly, if you look at the provision, as I was saying at that time, if you look at the provision of Section 231, particularly subsection 4, you will know that a calm reading of that section allows even somebody who's actually suffering from infirmity of body or mind to step aside. Later, somebody will be, when he steps aside, somebody may be appointed. The most senior person, justice in that court may be appointed to fill that particular vacancy. Then he can come back later. If it's purely on that ground, he can come back later to say, yes, I'm now fit to resume my duty. That is the purpose of the provision of Section 231, particularly subsection 4, because that particular subsection says, until the person holding that office now resumes. That second leg of that particular section is saying that, okay, somebody may have that issue, and after having this issue, and he gets well again, he can come back and resume his duty. So that is the purpose of that section. So perhaps,
if you could just shed a little more light on that, I'm sorry if I lost you there. Are you saying that if he has signed his resignation letter, then another has been sworn in an acting capacity, that the one who's resigned can come back to that position if he says, I'm fit to resume my functions?
No, he wouldn't resign. He wouldn't resign. What he can do is to step aside. He may just write to Mr. President that, yes, I'm not feeling fine at this particular moment. I cannot perform the function of my office. Kindly appoint somebody to fill this particular vacancy until I'll be ready to perform the function of my office. That is the reason why we have even in Section 145 of the Constitution, where the President will be allowed to transmit letters to, a letter to the National Assembly saying, I will be going on medical vacation. Then, as soon as I'm back on that vacation, I will come and resume my office. If you look at, critically that particular subsection, it also gives a kind of leeway to the CJN to say, yes, I'm not feeling fine at this particular point in time. Then the President should appoint the most senior person to fill that particular vacancy. Then If it's now okay, they can come back and resume. That's why I'm saying they can resume his office. That is the action.
Well, just give us a moment, gentlemen. We need to go to a quick break, but we will be back in just a moment. Don't go away. Welcome back. We are with Ahmed Raji, Senior Advocate of Nigeria, and Abdul Fattah Sambo, who is an Associate Professor of Public Law, Faculty of Law, University of Lagos, University of Ilorin, I beg your pardon. Well, Prof, you did give us a scenario in terms of how he can perhaps step aside and come back to the office, but as it is now, can we categorically say, even from the point of law, that the horse has bolted from the stable?
That the what?
The horse has bolted from the stable, so this resignation has come to stay. Isn't that what it is from the point of law? Now, all right, that being the case, when the president said he resigned on a health ground, and whatever matter came up is an internal affair of the judiciary, what specific steps do you expect to be taken in that particular context where he says, well, look, it's an internal affair of the judiciary. How should this be handled?
Well, I think it should be handled carefully. It's truly an internal affair of the judiciary. And I see members of the justices of the Supreme Court and generally members of the judiciary are supposed to be seen, not to be heard. Because normally if this thing is taken out of what is called something that is within the internal affair of the judiciary, there is a danger, a very serious danger to the constitutional democracy, because there is a chance that politicians will take advantage of this particular opening situation and infiltrate most of the judgments of the Supreme Court. You will recall what happened at the time when...
Perhaps I should rephrase, let me rephrase that. What specific steps do you want to see taken, be it a template, as Mr. Raji suggested, or a framework, whatever it is, a structure, to ensure that issues like this are seen to be addressed, and then other matters concerning administration, welfare, all of those issues, you have a platform to address all of them such that the judiciary can indeed say, we're well and truly on our way to judicial reforms.
Well, thank you very much. I agree with the position of Mr. Raji on those reforms. I want to add that there should be a situation where the monies of the judiciary, at the moment they claim that the money of the judiciary is taken directly from consolidated revenue fund, but you only discover that in practice, it is only the salaries and allowances of some of these judges that are taken from consolidated revenue fund. Or there are situations where governors and presidents will still have to come into aid, or the CJ of the state or CJN as the case may be, will have to go cap in hand to beg some of these governors to actually come to their aid in terms of some of these facilities that are needed for the court. I've seen a situation where some of these justices were actually conducting a very thorough research without electricity. There was a time I visited one of the justices in the course of one of my researches, and I found that I saw him in a very dark environment. I was saying, my Lord, you don't even have light. And then my Lord was even sweating in that particular station. I mean, so that kind of environment is something that is that should be looked into. Money, there should be some level of financial independence for judges. And apart from these judges, the salaries and allowances of staff of the judiciary, apart from the judges, should also be charged on consolidated revenue fund. And that would, to a very large extent, allow them to perform their functions creatively well. The another important thing is, anybody who has been appointed as a justice of the Supreme Court, or perhaps a judge of any court for that matter, he should try as much as possible to be above board, and should try as much as possible to carry his, everybody along. I think what really happened in this particular case was because of perhaps the gap in communication between my Lord Justice Danko and other 14 justices of the Supreme Court. Because one of the complaints was that there were no meetings. And if meetings are not held, perhaps due to the ill health of the CJN, then it becomes extremely difficult for you to say, yes, you want to actually address some of these things internally. Meetings have to be held, they have to actually communicate. Then, apart from this gap in communication, we have to ensure that there is a situation where the appeals, not all appeals will have to go to the Supreme Court. Because sometimes you discover that matters relating to tenancy matters being held at the Supreme Court. And one important thing, one structural adjustment that I believe most strongly that has to be done is the issue of even creating the Constitutional Court. Because if you look at the situation of South Korea, for instance, they have their Constitutional Court. And within 1 year, we were able to discover that the Constitutional Court of South Korea were able to deliver at least 3,000 decisions of the court. And the decision of this Constitutional Court will be so much limited to matters relating to constitutional matters. And those who are actually experts in the field will be appointed as justices of the court. So that there will not be constant, if you see at the moment now, most political cases are actually, getting the attention of judges, and other cases are actually suffering. And the thing will not take, you could get, sometimes the Supreme Court is already giving cases for 2027, 2028 to hear those particular matters. So yes, I think
those court, you may likely rule the ruling of Dasuki today.
Can you hear me, please?
I do not know, sorry, I think we can hear Mr. Ahmed Raji. I do not know if he's on a phone call or whether he's also trying to say something in this conversation.
No.
Mr. Raji, I know that you've said... Okay, so I'm happy that you're part of the conversation. Can you hear me?
I can hear you.
Oh, great. I'd just like to, for a number of Nigerians, and I know that, you've asked that we try to move forward. Chamberlain will keep asking how we can move forward without really looking back. For a number of Nigerians this morning, they're trying to understand, why it was important that the president award the rank or the award of GCON on the leaving, on the resigning Chief Justice of Nigeria. Do you think that that was absolutely necessary?
Well, that is the prerogative of Mr. President, and which he has exercised. But let me say one thing. You have to be very careful the way you handle some public officers. Otherwise, you will destroy the system. Except it is totally unavoidable. And I mean it. It is totally unavoidable. You do not embark on any exercise that will rubbish on public officials, because that will tell negatively on your system, and it will be a dangerous signal to the external world. I'm not saying...
And a number of... Sorry to interrupt your thoughts, sir. A number of people will understand why it will be that judicial officers, lawyers, senior advocates will be very, in a hurry to try and form a shield around the judiciary at this time. Because you've just talked about how we need to be very careful how we treat someone at that level in the judiciary, especially at a time like this, especially when you also look at the circumstances under which his predecessor left office, Justice Walter Onoye. There's still been questions on that. So, but this award, a letter was written, that letter is so difficult to ignore. The CJN himself wrote a response, an equally lengthy response, and talked about dancing naked in the marketplace, more or less referring to the dangers associated with the letter which the Supreme Court justices had written. However, it is so hard to ignore that, that was still hanging in the air. There was no neutral arbiter to look through it, and since these things were already in the public space, to try and, enlighten the public. While the public is still trying to deal with that, then we hear this letter of resignation from the CJN, and then he's resigning, and then the president gives him an award GCON, saying that, you know, he's also thanking him for his immense contributions to the judiciary, which are been unprecedented. Very big words from a president who uses words very sparingly too, and rarely gives awards. I mean, if you look at his own tenure, 7 years, you can count how many people he's actually given an award. So there have been questions as to, is this too much of an attempt to try and shield the judiciary? Is this really going to help us without really trying to help the judiciary with the probity which some people are saying it is in dire need of?
Well, opinions may differ, but I believe Mr. President or the regime has learned from the Onogan's experience and will not want such to repeat itself, because errors were made in that exercise, and I believe there's now a conscious attempt to avoid such slips in this case. That is the way I will put it, if you can decode what I'm saying. So I want to believe that such offices, for example, the other time, the Accountant General or whatever was arrested, and the next thing was, 90 billion and blah, 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 this or whatever. Yes, it's a good thing to bust such, but is it good to go public that way? Is it good for the system? It does happen in other crimes, but what they will do is they will call such top functionary, privately sit down and resolve it because of the negative impact it's going to have on the morale. If you come out, you say one single public officer took out 90 billion in your system, what is that telling the world about your system? What kind of a system will one individual be allowed to take out 90 billion? Is that a system? So in an attempt to redress some wrongs, you have to be careful the collateral damage which may far outweigh whatever benefit you are going to get from what you are going to do. This is the point I'm making. I'm not saying sweep anything under the carpet, but develop schemes, ways to address it. Learn from how it is being handled in other world, in other climes.
Yeah, Mr. Raji, the question I'm asking, and some people will get the point you're making about, you know, it seems that you're referring to a probe, and some people will say, okay, fine, he's resigned. For a number of people, that should let sleeping dogs lie. But should we perfume it? I mean, for some people, that will be what a GCON, awarding a GCON will be. Isn't this trying to, you know, ignore that there is actually something in the room?
Yeah, you see, you have said there are allegations. And you said, in your own words, there has been no habitat. So, and if he has resigned, and the tradition is to confer on them such award or honor, why will Mr. President not confer on Justice Ibrahim Tanko? Why? Why will he deny him? And besides, what I've said is that I'm not saying Justice Tanko is an angel. I'm not saying that. But you have to handle such public officials carefully so that you do not destroy what you are trying to build permanently. You do not destroy it permanently. We have to be very, very... And we should look at whatever the complaints are as a kind of charter of reference. For those who are there, they look at it, oh, this, we commented about this, oh, okay, let us guide against this and what have you. And then we look forward. But if there are serious issues later, such can be looked into silently and carefully, not all these papers and what have you.
All right. Gentlemen, we need to go at those points. I mean, even the former CJN did say in that clip which you played that corruption will not be permitted in the judiciary. So even our laws also says no one is above the law. So one can then infer that conferment of a GCON does not preclude anyone from being tried if he or she is found wanting on the point of law.
That is correct.
That everybody's on the same page on that one.
That is correct. Are they not trying Abacha's family now?
Okay, so much about the language.
Who can be higher than the former head of state?
All right. Gentlemen, we have to thank you for coming on. Mr. Ahmed Raji, Senior Advocate of Nigeria, as well as Abdul Fattah Sambo, Professor of Law, Faculty, Department of Public Law, Faculty of Law, University of Ilorin. Thank you, gentlemen, for your time today.
It's my pleasure to be here.
We will be back in a moment, and then we'll still have some points of law. Fortunately, we couldn't ask the gentlemen what their position is on guns for citizens. I guess we'll do that some other time. But that is our next focus in a moment. Stay with us.